This is the opening of the Oldham County Code Enforcement Board for Wednesday. First item on the agenda will be the approval of the minutes. Has everyone on the board had a chance to read the minutes? If so, do I have a motion?
I'll make a motion we approve the minutes.
Do I have a second? Okay, second. All in favor say aye. Aye. Okay, motion. Now we'll go on to, you want to start with the first citation for today?
First item on your agenda is Citation 610, issued to 6200 New Cut Road, Crestwood, Kentucky. Property is owned by Mr. Andrew Eldridge, and he received a citation.
Yes, we should. Stop. Do this and get ahead of myself. We have to swear in. My apologies.
You solemnly
Someone
swear.
else.
You solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your belief and knowledge.
I do. The property was issued a citation for a zoning violation in July, and we've had no compliance with this property. He owns a couple of businesses that require commercial vehicles. One is a tow truck company, and the second is a dump truck business hauling gravel, earth products, etc. And those vehicles are kept on the property, which is zoned residential. This is a map off New Cut Road. It owns a little over 1 acre there. This kind of gives you a description of the condition of the property. These photos were taken in May. Dump truck. There's the rollback record taken in July. Another photograph taken in July. I've spoken to him several times. Basically, the issue is he has nowhere to store these vehicles correctly on a property zoned for parking commercial vehicles. He's even tried to obtain property outside of Oldham County and has had no luck with that. So, again, the property is zoned residential. He's got commercial vehicles on the grounds with advertising on them. I've made site visits out there in May 12th, May 17th, July 13th, July 20th, and July 21st. And we've had no progress being made. It's just, he operates a business and the vehicles are kept on his residential property. And that's really summing it up.
Do you have any witnesses here today?
No, and another thing I'd like to add is that the last time I spoke to Mr. Eldridge, he was pretty unhappy with me. I think it's just a frustrating situation that he's in with zoning regulations here in Oldham County, and it's just what he has going on and where his property and what his property is zoned for, it's just not going to work out. So when I issued him the last citation, it was actually here at the fiscal court building, and we just had no progress.
Is the respondent here? No, he is not. Okay. All right. Well, at this point in time, if the respondent is not here, does the board have any? I'm sorry. Thank you. Does the board have any questions of Chris about the SMAC?
He's paid citations previous, and what really is coming down to is we're getting to the point that him paying the citation is kind of, in my opinion, the lack of terms for his cost of doing business. And we're not making any progress on what the real issue is, and that's these vehicles being kept on his property on New Cut Road. And so I just continuing to issue him a citation and he pays it. That's arguably cheaper than moving the vehicles to a industrial or commercial lot where he can store those.
Other properties shown on the map in yellow, are they zoned the same way as this current property is?
For a fact that the adjoining properties that are residential as well, that property that's to the due east of his is zoned C conservation, CO1. Yes, that's conservation. But again, it's still, we're back here with these issues on his place, and that's why we're here.
That in the explanation here, term have a history with this. What are you talking about? Have a history with this.
I believe he's had code infractions going back as long as 10 years ago. It started back in 2011, I believe, when he had a unpermitted addition to his house. He was building a garage. And since then, this has been a chronic problem.
Other options that make besides fines be cost of his business?
There might be availability of a criminal charge under the ordinance. But in a lot of those cases, maximum penalty is still just a fine paid to a different entity. So I'd have to look at all the different sections of the ordinance to see. Sure, sometimes ordinances can carry jail time, but I think so far the ones I've looked at for code board hears, I think all maxed out with fines.
Be the maximum fine that we could give. It seems to be, since he doesn't seem to spend money, since there's nothing that's been shown that's changed with this property, the board has to do something.
I'm not sure what the fine schedule shows, but it does allow for increased fines for subsequent violations. How many has he paid already?
2021, he's paid one citation.
How much was that?
Bear with me.
Like it would have been 150.
150.
It's the same amount. So it looks like a second offense is 250, and then third or subsequent is 400. Contested actually comes before the board. 300, 400, and 500. I think the maximum fine criminal court under the ordinance is 500.
Now, regardless of how many times it goes back, it's within the year. And so yeah.
Can you tell us how many or how much he's paid in fines over those 10 years? My point is that we're clearly not fining him enough. I would look for a maximum fine as well.
I have to get that for you. I don't have that right.
That's what I was trying to come to, but it appears to me that after the legal advice, even with a criminal matter, it's only going to be $500. So our hands seem to be somewhat tied at $500, even if we could get $500, because this may not be up to that point. As far as the number of times, this will be the first time you dealt with him this year, so that's a pretty cheap fine.
He clearly is showing that he would pay the $500 and it's cheaper than him trying to relocate those vehicles.
Speaking to him, I mean, he definitely, I believe, has made an attempt to try and locate a property. It simply comes down to economics, and obviously property in Oldham County is not cheap, and he's looked at adjoining counties. And so I don't know if he would just rather continue this business pattern, or, I don't know. But yeah, that's where we're at.
It feels that way to me, that he's chosen to continue this pattern, pay the fine of relocating. And I would just look to increase the fine to as maximum as we can go. And if he defies that, then we maybe get something more severe.
I think what the issue is that obviously with the size of those vehicles and their weight, that when they leave his driveway, there's a continuation of mud and gravel that's put on New Cut Road. So nearby residents have expressed concerns that got gravel, mud, and obviously when it pours down rain, it's even worse with what's coming out from his driveway there.
Citation or Boyd's ordinance. I don't-
This was the big fish, so this is the reason I went after obviously the commercial vehicles on the property. Yeah, there are other, I guess, additional charges, if you will, we could pursue.
Great.
Oh, absolutely, yes.
Does he have a LLC or a corporation, or is he just operating under his own?
I know the tow truck business operates under a different name. I don't know what the dump trucks operate under.
Appears to me that he is openly in defiance of following the rules and regulations set forth by this board or this city and this jurisdiction. That's where I'm at with this. So it appears that our hands are tied to a limited thing. If we're just going to find him $200, he can do this for the next 50 years. But the problem stays. We're not fixing the problem. He's determined that he can pay it, and that's fine. But my thing was the board is supposed to remedy problems. We're not remedying this problem. We're not remedying this problem at all.
I think there's an additional avenue available, but it would require a significant amount of work. You could pursue an injunction against him in circuit court that would probably require approval from the fiscal court. So I can't say how to do that, but that it's available. I've never done it. That's the only other thing I could think of. I think it'd be cited over and over again. I'm not sure. should happen.
I'm just concerned about the president that we get, and if we just can, then we're gonna sit here and then let another case, not be judged fairly, in my opinion, because we're not dealing with this one in the appropriate manner, based on our limitations. And I'm concerned about that.
So what I heard you say was that we could go ahead and go forward with a possible motion for an injunction, to take it to fiscal court, to get permission to take it to district court or circuit court.
It would go to circuit court.
Is that the path you were saying? To take an injunction?
I think it would have to be taken in the name of the county, I believe, which would require fiscal court approval. And I'm just not sure who would make that request to the fiscal court, because we've never done it before. But that would involve drafting a complaint, filing it with the circuit court.
Just brought up is that the tow truck company is operated under Flintstone Associates LLC. So that goes back to what you were asking on the.
So it sounds like the injunction would be sought against multiple parties. He would have to be named individually, then all of his companies. So it could get pretty involved. There's also that criminal summons option. The different, even though the penalty's basically the same, the difference is in a criminal case we can force him to make an appearance in court, or at least an attorney to make his appearance, whereas for this board there's no way to compel somebody to come in. So that might be the next step if we're talking about one step time. Again, you might want to consider that's a lot easier to do.
Thank you. Well, besides, and we hear that he continually pays the fine, so the fine should just be one portion of it, and then perhaps look at this as a second item, because we do need to move this forward. He's not going to do anything different if we just fine him.
What is the maximum fine? 500.
If we're considering this his second offense in the last 12 months, it's a $250 fine.
Okay.
But in criminal court, the maximum is a $500. There's no requirement that you have a prior offense.
Can we make a motion to give a maximum fine and proceed with legal act?
We can do that, but let's follow the procedural matters. To start with that, and then we can get to that point. Oh, please go right ahead.
Every month. Ends up being $400 a month every month, $5,000 a year. All work in the process. No action.
There's no reason that can't be done. Can't say whether it's a good idea, a bad idea. There's no legal reason why it can't be done.
If I understand it correctly, and Matt, help me out if I'm wrong, but I believe I can issue a citation per day based on, like, literally if I drove by there every day and took a photograph and nothing has changed Monday through Friday, But your point would be 5 separate citations, 5 separate, that, I believe that, am I wrong on that, or?
Any reason why you could not do it that way?
It's just, obviously, we're gonna have to do something to,
Will he be made aware that he'll be fined every day or every other day or every day?
oh, yeah, I mean, I talked to him. I mean, he and I communicate. It's just that we're not seeing progress here. Is where we're at, unfortunately.
Mm-hmm. Mm-hmm.
I think we're at a point now where we need to think of the safety of the officer. This violation with this particular property is a consistent situation. So therefore, it's proven itself to be, in my thinking, hazardous, and he just don't give a darn. He's already come up with the method, and he's comfortable with it. We need to find a way around it.
Any other discussion? You're going to start with procedural matter?
You have to make a motion to start with procedural matter.
Go ahead and go through the procedural matter, and then we'll make the motion.
So the citation was properly issued on
21,
24.
21, the 60.
No, that was 2020. 7/21. 7/21. 21. To Andrew Eldridge. And the notice of this hearing was given to him on what date?
That day,
7/21. You want me to rephrase that in the form of a motion?
Oh, keep going.
I'm sorry, you want me to read this out loud?
You don't have to read all of it. You just have to read part of it. Go on down which one applies.
Which one applies? So I read that one. And then C, the respondent did not request a hearing to contest the citation.
Thank you. We have a motion on the floor that the procedural matters. Do I have a second?
Second.
A second? Take a vote. All in favor, say aye. Okay. Okay. Okay, who's going to do this order? Let's continue.
Okay,
Going into the zoning.
make a motion that the zoning ordinance was violated. Location. Let me give the address. 200 New Cut Road. An activity being conducted at the location, namely a dump truck service and tow truck business. It's a violation of the county ordinance, as it is not permitted to be used in this zone.
Okay, we have a motion on the floor that the zoning ordinance is found in violation. And do I have a second?
Second.
Have a second? I'm going to ask for a vote. All in favor say aye. Opposed nay. Okay, motion carries. You want to continue with the determination of penalty?
Is that terms of a remedial order then? Well, I make a motion that we apply a maximum fine of $250 and proceed with legal proceedings to get him to cease and desist. I make that kind of motion, or I have to follow these. Have to give a civil fine first.
What you want to do is whether you're going to give him time to bring the property into compliance, or you say that the remedial order is the property is to be brought into compliance within 7 days or within 7 days of the date of this meeting, and all part of the civil fine is due within that same 7 days. Then you'll assign what that fine is in the next paragraph.
I think that with this motion, we dealing with, this is not a new situation. This is an ongoing, reoccurring, consistent issue. So that's what we need to deal with. There is no more time, as far as I'm concerned. There's no more time, period.
So you could just say the terms of the remedial order is the property is to be brought into compliance immediately, and no fine will be waived.
Okay.
That this is a consistent problem. This is not a new issue. We need to make sure that that's stipulated. This is not a new thing with this board. The word years was used. That makes a difference as far as I'm concerned.
And let me make a suggestion that the language about taking legal action should be specific.
Need you to restate it then.
Either go to criminal district court for criminal charge or pursue an injunction in civil in circuit court. Criminal charge is somewhat more efficient and will have a more immediate effect. It can be done with little or no cost. Pursuing an injunction in circuit court may involve some legal fees. It will take months to come to a conclusion.
Please.
I'll try. There's a lot. I'll make a motion for a maximum fine of $250 be made due immediately, and file in criminal district court for criminal charge.
Second.
Okay, we have a motion on the floor that the maximum fine of $250 will be brought forward, that the fine will be due immediately, and that we will file in district court to move forward. We have a motion on the floor. I have a second? All in favor, say aye. Wait just a minute.
Part where it says factors for determining the amount of fine. So were there previous convictions for this violation? Yes. Citation was uncontested. And then Crestwood was there, how many site visits did you do? 5? 5 on there, and then it's the second offense uncontested is 250. Go through that for determining the penalty.
Okay.
Want me to restate?
Please go ahead and restate it.
All right.
This is determining the fine.
Just that part only?
And the second page.
Determining amount of fine and previous convictions for this violation is yes. Citation was uncontested. The officer observed several separate offenses. The ordinance prescribed the penalty for this offense states that upon the conviction, person or he'd be fined for a second offense, $250 per day.
This is the motion on the floor. Do I have a second?
Second.
Second. I'll take it for a vote. All in favor say aye. Motion carries. Thank you very much, Chris. We'll move on to the next one. Oh, I'm sorry. Oh, thank you. Thank you very much. 5-minute break.
The next item on the agenda is 3016 Heather Green Boulevard. Citation 605, and it's owned by a builder of Jefferson County Provident Homes Incorporated. The citation has several violations, and I'm going to show you the photographs and then we can talk about it. There'll also be some other witnesses to testify today as well about this property. This was a build that started, issued a building permit, new build, excuse me, in January of 2020 for a new construction residential home. And in April of 2021, the building permit was revoked due to lack of progress being made at the build site. The photographs that I've taken were taken on 2 separate days one in July when the first citation was issued, and one in August when the second citation was issued. And you will see that, back up a little bit, this is a corner lot in Heather Green subdivision. And so that is what the property looked like July 6th, 2021. Obviously, it's framed, has a roof structure on top of it. And I'm not going to use the building terms that Mark Tice can testify to, but it's upright, and the lot had not been touched for months. And so the silt fence was completely ineffective. And again, this is in a subdivision with residents living on both sides of it. So kind of imagine if this was right next door to your driveway. The first citation was issued July 8th. Go back in August, and nothing has changed whatsoever. The property's not been touched. And really, the photographs really don't do it the justice that, because it's just been sitting there. So we're here today to unfortunately give you all some idea of what this place looks like, and the neighbors that are having to look at it and live next door to it, and something needs to be done. I was in contact with the builder. One time he called me after the citation was issued and told me the story that there had been an accident, he'd gotten hurt, but nothing was being done to the property to move it forward whatsoever. So that's where it is. The property looks exactly like this today. I drove by again. Nothing's been touched. Yeah, there's some residents that live in the neighborhood that want to speak.
I'm Carol Bender. Address is 4600 Timberwalk Court, Range.
You solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your belief and knowledge.
We are residents of the cul-de-sac that faces this house. It's been a lot that has actually been a problem for more than just the past year or so. It's never been, the upkeep has never really been done on it as far as mowing, trash in the lot, things like that. But this build basically quit around fall of last year. And we watch trash build there, and it's become a safety issue. Obviously, it's devaluing our homes. And like I said, we look at it every single day, pass it every day. It's the end of our cul-de-sac. And there is no movement. We did have a crew of several people that came out to weed eat it a few days ago. I believe that was possibly from the bank. But members of our neighborhood have also requested, called the builder. I personally have not. We have a Facebook page that does that, that we communicate. But we're really getting nowhere. And we're to a point of, the devaluation of our property. It's becoming a concern. This is over 20 months of building on a property that's that kind of shape. We hear the Tyvek flapping coming off. I mean, the roof is deteriorating. We're afraid that this is just basically going to be a demolition at this point. And then here we are again. There's a open lot that won't sell because of that. And, so it's stopping our neighborhood from progressing. Again, a safety issue. There's kids. There's a lot of small kids. We've had to run kids off from playing inside of the building. There's nails everywhere. There's big rocks. There's piles of dirt. That type of situation in a neighborhood that has around 100 kids. And there's also two main other things, which are there's a porta pot there that's been there 2 years, and we don't regularly see it being emptied. We do see delivery people, other construction people coming to use it, but it's still there. It's blown over. It's been put back up. It's there. I don't know if it's visible in any of these pictures, but there's also a trash cage that sits out there that's not been emptied in the period of time that build has been going on. People from maybe our neighborhood, maybe not, they're dumping trash in it. There's dog waste bags in it. There's, it's just becoming a complete problem for our neighborhood, and we're not able to get anything done. I mean, I realize our hands are tied. That's where we are.
Melanie Gelati, I'll spell the last name, it's Gigliotti, 3011 Heather Green Boulevard.
You solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your belief and knowledge.
I guess we've lived there in this neighborhood for 15 years, and we just want to see the neighborhood completed. There are 2 available lots. The builder, Dan Perkins, who built our house, who was the developer of the neighborhood, just recently had somebody interested in the lot right behind us that sits across the street from this house that is abandoned. And they walked away from building in our neighborhood because of this situation. My husband is, at the time that they submitted build of the architecture committee in the neighborhood. So he approved it. And they have just, it's going to have to be, much of it is going to have to be torn down because of weather and just nothing happening. It's quite an eyesore.
Tyson.
I swore in earlier. Mark Tice, I'm the building official for Oldham County. Just to give you a little bit of background from what my powers are or are not. I discovered this house to be in what appeared to me, for lack of a better term, an abandoned situation back in the winter. I contacted the builders, say, hey, what are we doing here? Because even at that point, it was obvious that no work had been done on it for quite some time. Wasn't getting anywhere with that. I don't have the power to make someone finish a project. That's, but you usually don't think you're going to need that. The whole object is to get projects finished. I do have the authority to revoke permits when they've gone 6 months or 180 days, whichever, without any work being done. I revoked the permit in April strictly to try to force some action. We need to do something here. So I've been dealing with it myself for quite some time. I can't remember exactly when I got Chris involved because, I don't have the ability to fine him for something like that. So started working with Chris on it, and there's just really been no movement from this builder. I want them to sell it or something, anything to get it finished. Why they don't want to do that, I have no idea. And they're not very forthcoming with us on any remedy. The house is getting at the point where when it is re-permitted, because I won't allow work to start back on it until there's a new permit. Because as part of that, I'm going to require a good bit of remediation be done on the property. So I'm not stopping them from working on it, but I am stopping them from working on it. I want the thing done, but I have to make sure that it gets done right. So what we're doing in the building and inspection department we're not holding the show up. We're actually trying to force the action and say, hey, let's get this thing done. And I feel really bad for the residents there. Anybody got any questions? Thank you. Yes. It could at some point in time get to fall under our dilapidated structure ordinance, I guess. That's a tough one. Chris knows more about it than I do. That falls under code enforcement. It could, I think you're probably gonna get into a pretty good legal battle on something like that to have it ordered demolished. I mean, unsafe structure, there is unsafe structure in my building codes. That generally is used for a structure that is deteriorated over time. Any house under construction is an unsafe structure until it's finished. So that would be kind of a stretch for me to call it an unsafe structure, because I'd have to call every house under construction an unsafe structure. So I have to be real careful with that. Does that help any? Probably. January of 2020. So it's quite a ways. About a year and 3/4. Yes, almost at this point in time. And I don't know exactly what date construction stopped on it. I know the first time I noticed it, I was kind of shocked, because it's most of Heather Green is built out. So I'm not through Heather Green all the time, doing inspections or whatever. And I happened to be over in something else, and I came across it and I was like, whoa, this had been worked on in a long time. And at that point, immediately tried to start getting something done, and I'm having no luck. The builder's just been pretty much unresponsive. I don't know what the lender situation is.
Hear of what you did in April?
Yes, absolutely. Like I said, the building permit was revoked to try to force action, let's get done.
Did any reply from him when you revoked?
I got a reply that it was a couple of guys, or a couple of gentlemen were brothers, that one of them had left the company and the other one had broken his back, and I didn't get any kind of resolution, and nothing's been done since then. So, and Chris has kind of gotten what little bit of communication we've had, which it's been tiny, has been just the same rate. We know what bank is doing the financing.
Okay, sorry. I didn't realize it had turned off. Is there any financing or anything in the paperwork that could give you a lien toward the bank,
We know who
the bank is?
and we've even contacted
Okay.
them, that we're gonna, we're at the point now is we figure our best thing is to levy as many fines and put as heavy liens on as we can to force sale. I think in Oldham County right now certainly is sellable. So that's, and we haven't, we kind of told by the bank their hands are tied too. So I don't know why, but that's their business, not mine. But we did contact them.
Thank you.
We've been trying. I promise you, we've been trying.
Thank you. Thank you. Any other questions of Mark at this time? Any questions of Chris? I'm sorry?
Discussing citation 605 or 611?
611 was the second citation, which brought them here. So what happened was 605 got nothing. 611 was the citation, just basically ordering them that's going to go before the code board.
And I make a motion that the citation was properly issued on August the 2nd to Providence Homes, the owner of the property. And the notice of this hearing was given to the respondent on August the 2nd, 2021. The respondent did not request a hearing to contest the citation within 7 days, but was notified and failed to appear, therefore is deemed to have waived his right.
Okay, now the motion on the floor, do I have a second? Second, I'm going to go for a vote. All in favor say aye.
Aye.
Nay, the motion carries.
Under a nuisance ordinance violation, I move that condition or use of the premises are detrimental to the properties of others or causes or tends to cause substantial diminution in the value of other properties in the community, as well as the storage of junk and lumber and other debris. And that the condition of the use of the premises renders the property dangerous or detrimental or adverse to the health and welfare, or are offensive to the senses of the residents of the community, property maintenance, overgrown property, lack of maintenance, etc. The violation was observed by the officer on August 2nd, 2021, and there is substantial evidence in the record that the violation has been permitted to exist for about 16 months.
Okay, we have a motion on the floor that there's a nuisance ordinance violation. Do I have a second?
Second.
We have a second. We're going to go for a vote. All in favor say aye. Nay. Motion carries.
Make a motion that violation of Oldham County zoning ordinance was committed because the location is zoned residential and permits have been revoked. As well as there is a condition that exists which is an eyesore to the community, violation of zoning ordinance 280-1.
Okay, we have a motion on the floor. Do I have a second? Okay, we have a second. Going to go for a vote. All in favor say aye.
Aye.
Opposed, nay. Motion carries.
You know, I hear in these emotions, but what I'm looking at is also a safety hazard in terms of children that has not been mentioned. I'm looking at a health hazard of we have a porta potty that's been blown over and people are consistently using it. Those are pretty heavy offenses. Plus, I see rocks around them, a big pile of rocks all in front of the place where children can get on, fall off, break a leg, hurt an arm. So it is a gross safety hazard on more than one level.
Okay, what time here? Is there a code that I need to put in? Just go ahead and make the motion. No, he was making a comment. There are other code violations.
But you have the other code violations is the construction site runoff ordinance and the Oldham County construction / demolition debris, which is the two ordinances, the 05, 830, 326, section 7 is the stormwater site runoff ordinance. And then the OC, the Oldham County construction and demo debris is the 94, 800, 846, 97, 830, 53, section 1. So those would be what you're looking for under the other code violations. And as Mr. Turner stated, that it's also a safety issue.
Mr. Turner, would you like to make a motion?
Motion.
She'll tell you.
With procedure matters, right? Citation was issued on
And we're under the other code violations.
the other code violations would be OC construction site runoff ordinance and OC construction thermal debris. Motion of C was observed. What C was observed about the following duties by the officer on or about the following duties. So the date,
August 2nd.
dates, August 2nd, August 2nd.
Thank you, Mr. Tucker. We have a motion on the floor. Do I have a second? You have a second? We're going to go for a vote. All in favor say aye.
Aye.
Opposed, nay. Okay, the motion carries. Take it down to determination of penalty.
Gonna go and go and thing. So my thing is that I don't want to give them 30 days. I want to give them the least amount of time that we have to give them legally because this is another ongoing and consistent problem. They are aware of it and it needs to be dealt with now. I don't know what the legal thing is in terms of how much time we have to give them, but I want to give them the least amount of time to deal with it because this is our new.
Well, the consequences of not paying the fine would be limited to having a lien placed against the property. And as ironic as this might sound, placing a lien against the property may slow things down a little bit because there's already litigation involving the property. There's multiple parties asking the master commissioner to sell the property, which is, I think, what needs to happen. I intended to give this information at the end of the hearing. I typically don't provide fact information to the board. I just provide opinion and guidance. But there was a lawsuit filed in June. It's a foreclosure, and it looks like it's moving right along. So they're going to be able to accomplish, I think, what the board wants to see much faster than what we could do if we were starting today. But if we place a lien against the property now, then they may have to go back and kind of start all over and include the code enforcement board or the county as a lien holder. So that might not be a good idea just yet. If their lawsuit accomplishes what everybody wants, I think we should probably see if it plays out without us placing an additional lien.
Thank you, Matt. Based on this information, then asking them to work with the master commissioner to go forward with the foreclosure.
Well, let's give them 30 days.
About that.
We don't want to mess it up, so let's give them 30 days. That'll give us the legal time that we need for this process to go on, and we won't interfere with the process already.
Okay.
Give them 30 days.
Mhm. Well, this is the first offense. Second offense. No, the second.
That'd be the second.
Is this the first offense or second?
First citation was was the 605 citation written in July. And then
Second citation.
It's not the second offense.
Remedial order first. You've not voted on that yet.
All right. In order for the terms of the remedial order, Mr. Tucker, would you restate what you said? Or, I'm sorry.
We will give them 30 days.
Okay. All right. Motion on the floor is that we give them 30 days to comply with this order.
Property into compliance.
Okay. Do I have a second?
Second.
Okay, I have a second. I'm going to call for a vote. All in favor say aye. Nay? Okay, motion carries.
There were previous violations, yes, at least 2. And this was uncontested. This is the second time we've called it. Officer observed at least he observed it at least twice. For 16 months. And we allowed this to go on for 16 months. We can hold the amount that we want to fine them. They're gonna bring it into the property. After them. If not, if they don't, then $100 if we can get it, or the 200 is what we can get.
200 on second offense.
200.
Is it unsafe 5,000?
You have multiple offenses. So if it's uncontested, the construction site runoff is 500. Demo debris is 4,000. Nuisance is 250, and the zoning is 250. So that's what you
And 5,000 is it possible?
5,000. 5,000 will be fine.
hold that in abeyance as long as they meet the terms of the remedial order.
We'll hold that until
Okay, Mr. Turner, you're saying,
30 days.
okay. All right, I have a motion on the floor that Mr. Turner has made that the fine will be $5,000 to be held in abeyance if the property is brought into compliance within 30 days. Is that correct?
Right.
Okay, do I have a second? Second. All in favor for the vote, say aye.
Aye.
Opposed, nay. That motion carries. Okay, is there any other comments on this one before this one's wrapped up? Okay.
Last item on the agenda today is old business. And if you remember from our last code board meeting, citation 580 was Belknap Beach Road was a zoning ordinance. I was down there just the other day and those pieces of equipment and vehicles aren't on the property. So I don't know where they've gone, but they were not there the other day.
Been removed. Okay.
7501 Lone Oak Court in Crestwood, that was a construction site runoff. That case was, for lack of terms, dismissed. And so we're good on that as well.
All right. Is there any other business to bring before us today?
Oh.
Being no other business? I'm sorry?
Chris, For the presentation graphics, shows the property and the locations of the property and photos that have been taken.
I don't put those together. I've got a lot of folks that help me a lot on this, so credit goes to everybody in the office.
It's a good team. All right, anything else? Okay, being no further business, we are adjourned.